Namaskar viewers, hello and welcome to Sansad TV. I am Tina Jha, you're watching Perspective. Judgment writing is a critical instrument in fostering the rule of law and in curbing rule by the law. That was the assertion made by the Supreme Court on Thursday while delivering a judgment on how to write a judgment. A bench of justices D.Y. Chandrachud and A.S. Bopanna noted that the purpose of judicial writing is not to confuse or confound the reader behind the veneer of complex language, because it speaks to the present and to the future in settling crucial issues of law, besides providing a platform for societal dialogue. Setting down guidelines for judicial writing, the two-judge bench underlined that the confidence in the judicial process is predicated on the trust which in fact the written word generates. And if the meaning of the written word is lost in language, the ability of the judge to retain the trust of the reader is severely eroded. So how can courts and tribunals provide an easy-to-understand analysis of the issues of law and fact in their verdicts? How can judges ensure lucidity in writing judgments? How can judgments be more structured? These are aspects on which the Apex Court has given directions, about which we will talk in greater detail with eminent experts who are joining us on the program. Pleased to welcome in the studio Dr. Vageshwari Deswal. She's Professor, Faculty of Law, University of Delhi. Professor Deswal, thank you for your time. Welcome to Sansad TV. Also pleased to welcome in the studio Dr. Rajiv Nanda. He's Senior Advocate, Supreme Court of India. And joining us virtually is Dr. Justice Satish Chandra. He's former judge, Allahabad High Court. Justice Chandra, thank you for your time and welcome to Sansad TV. Dr. Nanda, allow me to begin the program today with you. So we'll discuss each of these aspects in greater detail. But for the benefit of us and our viewers, give us an overview of some of the important guidelines that the two-judge bench of the Supreme Court today has delivered on how to write judgments.
First of all, I must say that this judgment is a milestone judgment and will be read for times to come. But there are other judgments which are passed in past, laying down the same principles of law governing the writing of judgment. This judgment, which has been passed by Honorable Justice Chandrachud and Justice Bopanna, reiterates the earlier principles, saying that judgment is a decision by a person who's heard the matter, heard the dispute which has been argued before him. It is the heart and soul of the judicial process. So it should be in a language which is as far as simple, because if we complicate the wordings and is understandable only by legal family or the legal fraternity or the legal courts, then perhaps it will not be welcomed by the people whose lists the court is deciding. The court, what is a judgment? Judgment is a decision by a person who's heard the dispute. So the parties must, and the judgment, this judgment of Supreme Court lays down the law that a judgment should be understandable in simple language to people whose dispute is being decided. The reason behind it is this justice should not be only done, it should be seen to have also been done. And secondly, if the reasons are simple and plain, certainly there will be no ambiguity and arbitrariness will be avoided. So to avoid the arbitrariness, the simplicity of the language should be there. This is what today's judgment lays down.
Absolutely. So how these changes can be incorporated is something that we will, of course, come back to and discuss in the course of the program. But let me bring in Justice Chandra. Justice Chandra, as someone who has written and delivered hundreds of judgments, how do you look at these aspects that have been underlined by the two-judge bench of the Supreme Court today on laying down some of these guidelines on how to write judgments?
The Honorable Supreme Court has passed the structure against the Allahabad High Court, Himachal High Court, who has the judges have written this judgment. Earlier also against the Himachal High Court and one of the Allahabad High Court. The Supreme Court observed that judgment's writing was not correct or was confused. So what is the correct procedure for writing the judgment? This is a very debatable issue. I can say the writing of the judgment requires the skill of narration and like a storyteller. So there should be no break. And what is the storyteller means the facts of the case. What are the facts of the case and what have been discussed, admissible positions of this one. When we uphold the examinations for the higher judicial services, there is a compulsory paper for the judgment writing. And there we said in the caption title, first of all, you give the court name, if possible, the name of the presiding officers and the suit and criminal case number and charges, what are the charges against, and detail of the plaintiff, detail of the defendant, and if it is a property suit, then the detail of the property, what is there. So all these natures against which order the person has come to the High Court, either in a writ petitions or in appeal. So that should be mentioned there. And brief facts will have to be discussed, brief history of the case will have to be discussed, but continuity must be there. There should be no break. And issue of the what are the issues in the civil cases and what are the charges in the criminal cases. So there is a little difference in civil cases and also the criminal cases, as well as for tribunals or tax matters. There are different views for writing the judgment. There are different styles, but fact remains that continuity must be there for the issues what is there, and there should be no ambiguity in the judgment. One person is reading the judgment, there should be no ambiguity, and all facts must be in a systematic manner, just like a story. All facts, and that will come there. Specifically, they should mention and what are the submission of the plaintiff after all this brief discussion. What are the submission of the counsel of the plaintiff or the petitioner who is on the side, and along with the case laws.
You know, two important aspects, Professor Deswal, that has emerged from this is a language which is easy to understand, and of course in a structure that is simple for those who are impacted by the outcome of these judgments. So if we talk about the linguistic diversity, we've seen a lot of emphasis being made by a lot of former judges, also top leaders, eminent personalities in the country, about how these judgments should be in a language which is easy to understand. That perhaps has not been able to happen. How can we encourage linguistic diversity when it comes to judgments and verdicts in our country?
See, this is something which is very important, and this judgment in this direction is a much awaited step. Because see, what happens, law has always been perceived as a very elitist profession. See, what happens the moment a student enters the law school, he gets this kind of a false notion that his language is to be something which has to stand out. He follows the tradition, something that has been handed over to us by our seniors, and that is something which we have been further perpetrating down the line. See, what happens, most of the legal jargon, as I would put it, it consists of these Latin words and other alien words. Now, what happens, most of the time when we read these words, we are not even able to pronounce them properly and to understand the meaning. A law student might comprehend what it is, but for majority of the people, it is literally Greek and Latin, as they put it. So what happens in this judgment, the point that has been highlighted is, the judgment should be in a language which is comprehensible to those for whom it is meant. And it is not only the lawyers who have argued the case before the courts, it is meant for the litigants. Yes. And majority of the litigants might not be knowing what the legal language is. So if they cannot decipher the intricacies of that judgment, and then moreover, the judgments, once it is given by the court, it serves as a precedent. So in case there is too much of a technical or formalistic usage of legal terms in that, what happens? It becomes difficult to use it. But somehow we have imbibed in us that, see, the tougher the language that I use, the more technical that I make it sound or appear, maybe that will give an impression of how well learned I am. So we need to curb this kind of a tendency, because ultimately, as the lordships have said in this case, the judgments, they are meant for the common people. And if they cannot understand, they again have to go to their lawyers to ask that what was written in the judgment. See, like I'll give you a very small example. Whenever we talk about judgments, we always refer to the ratio and the obiter. Now, majority of the people don't know that ratio is something which is just the reasoning behind the judgment. An obiter is just certain crucial observations which are pertinent to the main issue or some other issue in hand. But see, instead of using these common words, why do we still resort to those words which were handed down to us? So these are just by virtue of tradition that we have been following these
Absolutely.
practices.
And these are changes that we have to imbibe with time, make it simpler for people, Dr. Nanda. As someone, you're a senior advocate, and I'm sure you would have come across situations wherein people whose cases you are fighting for, you have to actually make them understand what the judgment has been. Because a lot of the times, as Professor Deswal said, it is difficult for the people to comprehend what the judgment actually says, what it means. So not just in terms of simplifying the language, but also in the format and the structure in which it's written, how do you think that simplification can happen?
Yes, it's a very good question you've asked me. The simplification of a judgment is a very important factor in writing a judgment, because unless and until it is not understandable by the person for whom it is meant, in my humble view, it is not a good judgment. So how it should be simple? It should be, one, in a chronological manner. Two, it should be germane to the facts. It should not be vague. And as far as possible, only facts of that case should be discussed. The personal knowledge of a judge, which is not the subject matter of that record which is produced in the court, should not be discussed, because otherwise it will create confusion, the personal knowledge. Secondly, and another point which is very important in writing the judgment is that the obiter dicta should be avoided, which is not relevant. The obiter dicta is, as Professor Deswal said, is something which is not deciding the case. The judgment should try and avoid all those writing in those paragraphs which are not germane to the facts of the case, because if something is written in a judgment which is not there, part of the record or part of the facts, it is going to not only create confusion, but the justice delivery system will also be affected, and the last person standing on the street for whom this justice delivery system is made will not understand it. So to write it simply, it should be, as I said repeatedly, that it should be in a chronological manner, based on the law in vogue at the right time. Like, I'll give you an example. Like, you cannot be punishing a person for an offense which was not an offense at the relevant time when he was charged about it. And similar is about the tax. You cannot be taxing a person for an activity which was not taxable at the relevant time when the activity was done. So if the judgment is not written in a simple manner, the person against whom it is being written or whose dispute is being decided will not understand it. To make it more simple, I will say to put it in a chronological manner, in as far as simple English, to make it understandable by a common man, is the essence of a judgment.
Absolutely. Justice Chandra, so, a number of aspects and changes suggested by the two-judge bench of the Supreme Court on, how to write judgments and make it easier to understand for the people who are impacted by the outcome of these verdicts. But coming to how these changes can now be incorporated, because every judge has a different style of writing judgments, how difficult will it be to incorporate these changes of which we are talking about and which we are hailing as landmark move?
Madam, you are right that every judge will have to write the judgment in his own language, own way. So that is one thing. But fact remains that in judgment, there must be the continuity of the facts. As my co-panelist said, the chronological discussions, and I earlier said that there must be the continuity like a storytelling writer. And all facts should come out. Then case laws, in those facts, what is the applicability of the case law? That should also be mentioned. And when you are reaching at a final or conclusion, then you must give the reason for your decision, why you have arrived on a particular point, not by discussing everything and I said I acquittal. There is nothing like that, but you give the reason, there is no other option except this one, and what I am holding that one. So judgment can be there in the sun. And now, madam, before few minutes, my co-panelist said that terminology, or you can say the idiom or maxim or cannot be used. But there are few instances where maxim can be used, but immediately the meaning should be given. For example, ignorantia excuse non lua, meaning thereby the ignorance of law has no excuse. So meaning should be given, or means should be given after this one if it is used, because otherwise you will have to trace the case law, and one person will say at that time I was not aware that this is the crime and it attracts the penalty or something like that, because ignorance of law is no excuse. So sometimes we will have to use the maxim, but immediately you will have to give the meaning of that maxim and supported judgment, if any, Supreme Court may be also mentioned there. And then you can say that the person was well acquainted about the crime and he was having full knowledge, so no excuse can be saved, and this plea cannot be accepted.
Okay.
That ignorance was there.
Professor Deswal, so that's an important fact that Justice Chandra has mentioned and that has also been underlined by the Supreme Court is no judgment can be without a reason. But hasn't that been a principle while delivering judgments? And where are we lacking? How do we now need to incorporate these changes? Will there be changes required right from training so that all of these are implemented effectively?
See, there cannot be a judgment till the time reasoning is given for the judgment. But here, in this particular judgment, what Justice Chandrachud has very aptly pointed out is that because of technological advancements, what has happened that we don't hesitate in this cut, copy, paste style. Now, what happens, we've seen the judgments, they run into hundreds of pages. Okay, and what is like a typical format of judgment, I'll tell you. Like first we give the facts that are on record, and after that what was the evidence that was tendered by both the parties, then arguments coming from both the sides, and thereafter if there are any similar judgments on same facts, whether there have already been any authoritative judgments pronounced by any high courts or Supreme Court on this. See what happens, more often than not, the lawyers who are arguing the case, and they just keep on arguing, and the thing is that they believe that what they are saying is very, very pertinent, very, very crucial for the case, which might not be so, but they are convinced. So these are cases of ignorance coupled with arrogance. And what happens that they'll not stop at anything, and then they'll quote one after the other authorities, and sometimes the lordships, they also feel compelled that maybe we need to include all these authorities in our text, in our judgment also. And as I said, it's all very easily available on the net. What happens, they keep on adding all those authorities and all, which might be relevant, which might not be that relevant. And then there's a possibility that after quoting a couple of cases, you don't have to quote all those cases. And that is the reason why our judgments, they just flow into, as I said, hundreds of pages. So we need to strongly curb this tendency. One thing. Another thing is why we resort to this legal jargon is because we believe that maybe this is something which is precisely and exactly explaining what the legal meaning of this, what legally I want to say. But that is not perfectly true. We can always come up with substitute terms to simplify that.
Absolutely.
Okay. So what is required is we should be having judgments. I don't say that they should be only 4 or 5 page judgments because that is practically not possible. But yes, for reasoning, we don't have to necessarily quote all these legal terms and all, because legal terms, some we can't, like, of course, we can't compromise on certain terms. But then if you have seen that even if we talk about the standard, how we frame those commercial contracts, even a simple thing as a registry of a land deed or a sale deed, or if you talk about a lease deed, I mean, these are all so complicated, and we've just been following the tradition without challenging, without questioning. See, this is an alien system which was handed over to us by the Britishers. Maybe we need to change it. Now, English is not our language. Or that's a different thing that we Indians have aced it. But still, if we can bring in very easy terms to substitute those terms that have been handed over to us, if we can overcome that kind of a mental block and write something which is very easy, very simple to comprehend for each and everyone who wants to understand what has been written, I think that would be a very good
Absolutely.
step.
And apart from that, Dr. Nanda, what's also been spoken about, and which is the underlying fact when we talk about and we look at the state of our judiciary, is that incomprehensible judgments today are impacting the dignity, lowering the dignity of the judicial institution. Where exactly does the problem lie? Where is it emanating from? And how can we ensure that the work of courts, of judges, cannot be just reduced to a statistic about disposal of cases, but there should be substance, there should be reason, and there should be logic behind the outcome of the verdict?
Yes, rightly asked me this question. The judgment, in my view, should be first describing what all the factual position is. Maybe it's a commercial contract, maybe it's a criminal matter, maybe whatever it is, a civil matter, a family matter. It should, in a chronological manner, give the facts and then say what are the issues arising out of the facts. Then should be what are the arguments advanced by one party and what are the arguments advanced by the other party. And then what is most important is why the judge is rejecting a particular argument and why the judge is accepting a particular argument. Now, what you asked me is what is affecting. See, it's very subjective. The authors, you cannot put them in a computer form and say that this is the manner in which judgment should be written. But most of the time, why the load of the court is being increased is because of the manner in which judgments are being given. They are not understandable in the manner I just said it should be. If the judgments are written in the manner, as I said, facts and the issues which are decided, and every issue which is raised in a dispute should be decided by the judge in the given judgment. If it is not decided, it will lead to ambiguity and arbitrariness, which will lead to further appeals and all that, and add to the backlogs of the judicial system.
Absolutely. Justice Chandra, I think the most important fact that has come from the discussion today is that all courts, be it constitutional courts or the tribunals, they have to ensure that there is clarity in their verdicts, because it is not just impacting the present but also have a bearing on the future. So keeping that in mind, all of these changes, of course, are very necessary, important to incorporate. We've spoken also about the kind of challenges, but what is the way ahead? By when can we expect these changes to happen? These have been long pending, as Professor Deswal was reiterating. This is a system that we sort of inherited, and we have just been blindly following it over decades.
You are right, madam, but question this. There can't be a standard form of judgment, because judgment is given by the human being, not by a computer. So there can't be a standard form of judgment. When facts are established, as we discussed already, when facts are established, undisputed facts are established, then after the arguments, facts will be decided by the court. And when facts is decided by the court, what are the situations in the law? Then case law will come. If you don't agree with the judgment of the higher court, that is Supreme Court or High Court, whatever may be, so if you are not agree, then give the reasons, because Supreme Court itself says that every judgment will have to read in its facts and circumstances. That is there. And if facts and circumstances are different, then you can distinguish that judgment or declare it in per curiam. If this judgment is in per curiam and these facts are not applicable, this judgment is not applicable, and then come to your conclusion and with the reasons. What are the reasons? So my suggestion is this, that there must be the continuity of the facts, clarity, reasoning must be given, and case laws will have to be followed. If you are not agree with the case laws of the higher court, then give the reasons and distinguish it.
Absolutely.
That is there.
That's a very valid point and very significant one pertaining to our judiciary. So these have been changes that have been suggested by the two-judge bench of the Apex Court. We've discussed the important aspects that have been underlined by the Apex Court today. And these need to be incorporated because, as all our panelists were saying, these are changes that have been the need of the hour. And it's time that we need to evolve and transform our system so that it's easier and effective for the public at large, because ultimately these verdicts, these judgments from courts are impacting them. So that having been said, I'll have to wind up the program. Thank you to all my guests for joining me on this edition of Perspective today, sharing your thoughts, your views with us and our viewers. Absolute pleasure to have all three of you join us on this edition of The Perspective. So that's it from us on the program today, viewers. Thank you for your time as well. I'll see you same time tomorrow now with another topic and a new set of panelists. Until then, take good care of yourselves and keep watching Sansad TV.